Good day, everyone. I am John, your moderator for this webinar on the behalf of the organizer company called Conference Panel. I welcome everyone for today's webinar, which is called Medical Records and Abortion, HIPAA Confidentiality, and Law Enforcement Exceptions Applied to Abortion Records. So now, I would like to introduce our presenter for today, Mark R. Brangelman. Mark R. Brangelman is an experienced attorney in administrative and professional licensure law, representing a wide variety of professional clients from licensed individual healthcare practitioners to licensed healthcare facilities and many others. As a frequent participant of continuing education, Mark has been a presenter for over 30 national and state organizations and private companies as the Kentucky Bar Association, Kentucky Office of the Attorney General, National Attorney General Training and Research Institute, and Federation of Associations of Regulatory Boards. Now, I would like to hand over the floor back to our speaker. Over to you, Mark.
Thank you, John. At World Headquarters with Conference Panels, this is Mark Brangelman. Glad to be here with Conference Panel for the next hour. Based on the content of this program, you will be able to effectively identify basics of HIPAA privacy for patient records, exceptions for law enforcement for civil and criminal matters, state authority of licensure boards and agencies to exploit HIPAA exceptions against healthcare practitioners on investigation regarding abortion, and know about how exceptions to HIPAA privacy may be applied and are applied by law enforcement agencies with an emphasis on medical records of abortion. I have tried to style this and use the phrase medical records of abortion or records of abortion or records related to abortion because, as you will see, there is a vast trove of information that is data or records of abortion or related to abortion or connected to abortion, not just clinical medical records of an abortion that was provided. We're going to give examples of many of the other kinds of records and electronic data that are not protected by HIPAA that may be obtained by law enforcement. We will discuss how prosecutors may investigate and prosecute women who seek abortion care, people who assist them knowingly and unknowingly, and doctors, physicians, nurses, and other healthcare professionals who counsel or provide medical care regarding a woman's right to choose. We'll also have just a little bit about state open records laws and investigative laws that apply to protect you, the healthcare provider, when the state licensure board or agency has your patient's protected health information and medical records of abortion, and how those laws have their own exceptions that swallow the confidentiality rule. So what this does and does not cover, I always want to be clear about what our expectations are for the goals of the content of the program, because this does provide a broad overview of HIPAA confidentiality issues as related specifically to abortion records or records of abortion or related to abortion. It does not cover everything about HIPAA confidentiality or HIPAA as applied to any specific healthcare profession. It does educate the person attending to ask the right questions in their own state, their own healthcare facility, and their own profession of a healthcare professional about compliance with HIPAA confidentiality and law enforcement exceptions based on any given situation as they relate to abortion records. So the basics of HIPAA requirements for patient records. Remember, HIPAA is a federal right of privacy. There are state law privacy rights. There are at least, I think, 5 states that have additional specific medical records privacy laws. I'm not going to cover those, but just know that there can be state laws that apply. There's also medical confidentiality as found in state licensure laws, especially in mental health, less in physical medicine such as physical therapy. So in my jurisdiction, for example, there is like a 13-part state administrative regulation. It is state law promulgated by the state licensure board in that profession of psychology that has 13 parts about confidentiality of psychological records. Not to be outdone, another profession, professional counselors in the same jurisdiction, have like a 28 subpart, 28 section or part administrative regulation promulgated by that licensure board that doesn't reinvent the wheel about confidentiality. So with an overview of some HIPAA exceptions, this comes under the statutory and regulatory exceptions in the HIPAA privacy law for the, quote, uses and disclosures for which authorization or opportunity to agree or object is not required, quote. there are still some restrictions here and there, and I've labeled these, what we will talk about today, as exceptions for law enforcement purposes as they are used to access abortion records or records related to abortion. Law enforcement as a term can be broadly applied to the government. It's not just the cops and detectives. It can be civil enforcement agencies or state licensure boards. So with medical records and abortion and HIPAA confidentiality, these law enforcement exceptions are different from public health exceptions. There's been a lot about public health exceptions, or at least there was early on in this ongoing pandemic dating back to early 2020. For public health exceptions about state inspectors or public health individuals who knock on your door that if there's a COVID outbreak or something. But these are exceptions for law enforcement, civil or criminal, to obtain records as required by law. Next slide, please. To comply with a court order or court-ordered warrant, a subpoena or summons, or administrative request, the administrative request must include a written statement that it's relevant and material, specific and limited in scope, et cetera, et cetera. To respond to a request for information to identify a suspect, fugitive, material witness, the information must be limited to basic demographic and healthcare information about the person. To respond about an adult victim of a crime when the victim agrees or is in limited circumstances unable to agree, those are exceptions as well. Child abuse or neglect may be reported without a parent's agreement to any law enforcement official authorized by law to receive such report. So you may have a duty to report suspected child abuse or neglect, and in many states that's a very entry threshold matter that triggers it. So you may have a duty to report it. What I've read, I didn't include this part in the update to this presentation, but the feds are saying things like child abuse laws would not apply to abortion records. If you said this woman had an illegal abortion in this state and that was child abuse. So I hope we have covered all of this. Have we effectively identified the basics of HIPAA privacy for law enforcement purposes for civil and criminal matters, how state authority of licensure boards exist to exploit HIPAA exceptions against healthcare practitioners if a complaint is made against the doctor that performed an abortion. And by the way, don't think that some of these things are theoretical. A couple of governors ago, our jurisdiction had a governor who was a licensed physician. Thank you very much, everyone. This has been a really good and useful and worthwhile use of our time. I've talked nonstop for an hour. You've been wonderfully patient to hear me out. I enjoy doing these webinars. Look for a continued strong business relationship with Conference Panel for compliance and regulatory information and breaking topics like HIPAA and abortion. So there's my contact information, and look for us for future webinars with Conference Panel and ones that have already been provided. Over and out.